X Corp, the company formerly known as Twitter, is fighting to keep rights to its Twitter trademark in two separate legal actions that will in turn raise two very interesting trademark issues that don't typically arise. As a background, white supremacist scumbag Elon Musk was essentially forced to buy Twitter and rebranded it in his own image as X, publicly declaring that Twitter was dead. A couple of years later, a couple of lawyers decide they want to start their own new social media company. One of them, by the way, used to be counsel for Twitter. And they want to adapt the Twitter branding because they think they want to capture what Twitter once was. They want to call it Twitter, they want to use the word tweet, and I think they want to use the bird logo as well. When they applied to register the trademark in these trademarks, of course they were turned down because X Corp, which now owns those registrations are still active. So the new company, Operation Bluebird, filed the first action, which is a petition to the Trademark Trials and Appeals Board to cancel the trademark registrations for Twitter. X Corp, in turn, sued Operation Bluebird in federal court for trademark infringement because, as of now, Operation Bluebird doesn't have the social media service ready, but it does have a website and it's using the Twitter trademark, and they made public statements about how they're trying to capitalize on the goodwill of Twitter. X Corp claims that it still maintains rights in the Twitter trademark. To continue to use rights in a trademark, you have to be using those trademarks in commerce associated with the services. So the two legal issues at issue here, one of them is abandonment. This is where you used to have trademark rights, but you no longer have been using them, and therefore you've essentially abandoned them. In theory, trademark rights can last forever. However, you do have to continue to be using them in commerce in such a way that it is branded and that consumers associate your service or goods with that trademark. Of course, Elon Musk, in his indelible wisdom, has said that the trademark brand is dead, so X Corp is going to have to overcome that. It is usually difficult to prove abandonment of a trademark, but Elon Musk has given them reasons to be hopeful, Operation Bluebird, that is. The second might arise, which is called residual goodwill. Residual goodwill is when you have ceased using the trademark, but consumers still associate your goods or services with that trademark, and that you have an intent to resume using that trademark in the future. Now, I'm sorry to report that I do think Twitter has the edge, that is X Corp has the edge in this case. Number one, they have the active trademark registrations. They may be able to make some type of show that they have some type of nominal use of the trademark in commerce. I'm not convinced that everything they say in their complaint will be helpful. A lot of what they present in their complaint is evidence of third-party association. The fact that consumers still say, I still call it Twitter, and that other third parties still call it Twitter. However, X Corp does not mention Twitter anywhere on the services. So where there might be a public policy in favor of their keeping the trademark rights, there is case law that says once you've abandoned it, you no longer have those rights to enforce. You can take comfort that if X Corp does lose the rights to Twitter, it is because of the missteps of dipshit Elon Musk. One more interesting thing. The complaint, X Corp's complaint, cites an article by Cyrus Farivar in Ars Technica about this dispute, and that article quotes me, which means if you pull up X Corp's complaint, it links to the Ars Technica article, which in turn links to my website, which in turn you can see my son's beautiful nighttime photograph of the Bay Bridge. My name is Mark Jaffe, Five Bridges Law, representing creatives in California and New York.